this second podcast for Module 3, we're looking at the law in relation to family dispute resolution. That is, the legislative requirements in family law for pre-filing dispute resolution. Now, as we said in the last podcast, the overall objects of the Family Law Act are to assist people to be able to discuss and make their own arrangements for their children and also for their property. And this is reflected in the Family Law Act and also in the rules. Lawyers also have obligations, for example, solicitors under the Solicitor Conduct Rules, which are now nationally applicable and binding. So this ethical obligation is really to advise clients about alternatives to going to court. And that means that we really need to talk to our clients about trying to settle their case before even considering going to court. Now, there might be some cases in which this is not appropriate, for example, if it's extremely urgent, but I guess it's really a general rule. And as a lawyer, your approach to your client's case can make a very large difference, particularly in family law, to your client's well-being and the well-being of their family. Now, these types of things are also reflected in ethical guidelines for family lawyers, which are called the Best Practice Guidelines. Now, these aren't binding, but they really give us good guidance for how to approach different types of family law cases. So, for example, they set out that it's best practice in family law to take a constructive and conciliatory approach to the resolution of disputes. Also, to minimise risks to separating families, particularly being aware of safety, so that's relevant if there's been family violence issues, to advise clients to avoid arguments in front of their children, try to avoid exposing their children to the conflict between the adults, and that's really something that's very important. The social science research tells us that the most damaging thing for children is conflict, and being exposed to conflict, whether they're in an intact family or in a separated family. And obviously there's going to be some conflict in all families, and that's natural. But high-level conflict, particularly parents continually putting each other down in front of their children, pointing out to their children the bad points in the other parent, and having fights and particularly physical violence in front of children, is shown in the research to be extremely harmful for them. So I think it's really important to think about the role that lawyers play with their clients, and particularly when a client comes into you for initial client interview, how you can really set the scene and really influence the approach they take to their issues. If you're taking a collaborative, conciliatory approach, this will be reflected in the advice that you give to your client, and also any approaches you make to your client's ex-partner, for example, by telephone, by email, by letter. The tone of your letter and what you have in it can really make a big difference, because an aggressive initial email or letter can really inflame the conflict in a family law case. Now, another obligation on lawyers is to provide clients, when we initially see them, with information about where they can get help, for example, for counselling if they're thinking about reconciliation, or other types of help such as mediation or parenting programs, help programs, for example, for victims of violence, adult victims and children. So we're required in any type of family law matter to initially provide our client with this marriage separation brochure, and have a look at the brochure. I've given you the link there. So So if when you're doing your assignment and you're sending out your initial letter to your client, your letter of advice, you are required to attach this brochure to the letter. Now, it's important to understand in family dispute resolution that there are two different types of requirements in property and financial as opposed to parenting cases. The requirements in parenting cases are more onerous, so we'll be going through this in this podcast. Now, in property and financial issues, there's really an obligation to negotiate before even considering filing a court application. Now, in the Family Court of Australia, the family law rules apply, and what are called the pre-action procedures apply. So before filing a client's case in court, in the Family Court of Australia, you need to comply with the pre-action procedures. Now, these aren't strictly binding in the Federal Circuit Court of Australia, and as we said, most cases go to the Federal Circuit Court of Australia, but you'll find that Federal Circuit Court judges require lawyers and parties to attempt settlement before filing in court, unless that's inappropriate, for example, unless the case is very urgent. So it's now considered best practice for a lawyer to be attempting to settle their client's case from the very beginning, and to, for example, attempt negotiation with the other side. That can be attempted by ringing the other lawyer, sending an email with an offer of settlement, or organising a mediation, or organising a collaborative law process, and all of those types of processes will be acceptable. The actual definition of dispute resolution in the rules talks about negotiation, conciliation, arbitration and counselling. However, it is totally appropriate to attempt mediation or a collaborative law negotiation. There is a requirement for parties to make a genuine effort in negotiations, and that means the clients. There's no definition of genuine effort, it just means a genuine effort to settle. And normally what would be expected in that is that people don't just stick to their initial position. For example, I want 70% of the property settlement, unless that's totally reasonable, and that's what, so if they went to court, it's very likely that they would receive. Normally some compromise is really expected in negotiations. There are exceptions to these requirements of attempting to settle before filing in court. I guess the main one in property matters would be urgency. For example, if there is, say the former matrimonial home is in the husband's name only, the wife gets wind that the husband is organising to sell the home, and that's the main asset in the property settlement. That would be urgent, and unless something, I guess again you could try and urgently negotiate, but you may have to file proceedings in court. Another one is a time limit close to expiring, and remember we said that there was that time limit once you've got your divorce for filing a property settlement, so you have to be very careful about that time limit. Now, in all property and financial cases, both in family court and federal circuit court, there is a duty of disclosure, and what that means is that clients have to provide all information to the other client, their ex-partner, and to the other lawyer if there is one, that is relevant to working out a fair property settlement. Now, in this area of law, full disclosure would mean of their income, their assets, their debts, and in relation to the relationship, you would want to know what we call the asset pool is. So that is, what are the assets of the relationship, what are the liabilities? Also, what did the parties have when they first started living together, and what did they have upon separation? And generally people have to decide whether they will agree on the valuations of assets such as houses, any other significant assets. If they can't agree, they will have to organise valuations. Now, it's very important to have all this information for a lawyer so you can give your client accurate advice about what sort of property settlement they may receive when they go to court. And then you use that information to negotiate what might be a fair settlement. It might not be as much as they might get if they go to court, but something fair and taking into account the large amount of legal fees that they will pay if they go to court. Now have a look at that information about the pre-action procedures available at that link. Now in the Federal Circuit Court there are also separate provisions in relation to settlement. Now the Federal Circuit Court in Part 4 has a whole section on dispute resolution. So have a look at the sections. Now have a look at sections 21, 22, 23, 27, 25, 34. They talk about dispute resolution processes. They define them to mean counselling, mediation, arbitration, neutral evaluation, case appraisal and conciliation. Section 22 says, the Federal Court must consider whether or not to advise the parties before it about dispute resolution processes. Now I guess generally they would want people to try and settle before giving them a hearing date. There might be some instances where that's not appropriate. For example, if one client isn't providing full disclosure, sometimes people do try and hide money or assets. For example, they might have overseas bank accounts and they're not disclosing all of this information. Now also in that Act, the Federal Court and the Family Court for that matter have power to order the parties to mediation. So if you have a look at, for example, Section 34 of the Federal Circuit Court Act, it says that the Federal Circuit Court can order people to mediation. And this is becoming more common because unfortunately there are far too many matters in court. For example, if you file in court and you go through all the preliminary stages and you get to a call-over, which means a day when the court then allocates you a hearing date, at the moment in the Federal Circuit Court in Brisbane, there generally aren't hearing dates unless it's very urgent. This is for a final hearing until next year, probably March, April. So you can see that there is a lot of incentive on people to settle if possible, and a lot of incentive for the court to, for example, refer people to mediation. So you'll see, just going back to the property matters, so property and financial matters, there's no compulsory requirement to attend mediation. There's just a compulsory requirement to attend dispute resolution, and you can do that by undertaking all those different processes that we talked about. However, in parenting issues, that's about issues in relation to children where parents separate, they're working out the time children will spend with them, how they're going to change over their children, other sorts of matters. They might have to work out where they're going to school. Sometimes people argue about children's names, particularly surnames, sometimes Christian names. There is a compulsory requirement to attend mediation before filing an application in court. Now there are some exceptions. However, this is far more onerous than the requirements in property matters. Now these parenting requirements are set out in Section 60I of the Family Law Act. Now I should point out that in the Family Court of Australia, in parenting cases, the pre-action procedures are still relevant and they're in Schedule 1 of the Family Law Rules. However, generally in parenting issues, we tend to focus more on the Section 60R requirements. So what it means is generally parents have to go to mediation with an accredited mediator who's called a family dispute resolution practitioner, and they must have a certain amount of training and be registered with the Commonwealth Attorney General's Department. They then obtain a Section 60I certificate from the mediator, which is also called a family dispute resolution certificate. Now the certificate, the types of certificates are set out in Section 60I, subsection 8. There are different types of certificates that can be issued, but if the mediation proceeds, the mediator has to set out in the certificate whether both parties made a genuine effort. And if they didn't, for example, if one party didn't make a genuine effort or both parties, this is reflected in the certificate. Now have a look at Section 10F of the Family Law Act. It sets out the definition of family dispute resolution practitioner, but it really just says that they're an independent person who is helping people to discuss their issues. So you'll see here the definition. A dispute resolution practitioner helps people affected by separation or divorce to resolve some of all their issues, and they are independent of the parties. So that means they can't have had any conflict of interest. A family mediator can't have acted for one of the parties as a lawyer. They can't have seen one of the parties as a counsellor. They can't know one of the parties personally. They must be independent and not have any interest in either of the parties, as in a relationship from the past. Now there are exceptions to these requirements when people don't have to go to mediation before filing an application in court. So common ones would be urgency. Also, if people have reached agreement and they're filing consent orders, which is a written agreement that is written up. Once they've reached their agreement, they might have reached it at the end of a mediation. It's filed in court and it comes out as a court order. Another common one would be issues of family violence abuse. I guess just the fact that there are issues of violence may not mean that mediation is appropriate, but we'll see later there needs to be an intake process conducted by the family mediator to determine if mediation is appropriate and also whether it will be safe. So in some cases where there is family violence or for example, there might be current issues, allegations of abuse of a child. For example, one parent might be alleging that the other parent has abused the child or children. Those allegations are being investigated but haven't been resolved. In that sort of case, it's not appropriate to have a parenting mediation. The investigations need to be resolved first. In that case, I should say too, if the Department of Child Safety is involved, it doesn't mean there can't be a mediation, but depending on their involvement, for example, if they have a supervision order in relation to a child, an agreement could only be entered into between the parents if the Department of Child Safety are okay with that agreement, if they have a supervision order in place in relation to a child or children. Now Section 60J also says even if there are allegations of abuse or violence, as lawyers we must still give our clients advice about whether dispute resolution options might be appropriate. And in these cases it's really a matter of the context of the particular case, context of the allegation, also issues of safety for the victim or victims of family violence, and the sorts of things that may be appropriate are a mediation may be appropriate in the same room where the parents are in the same room, or it might be appropriate if it's by telephone link up, if it's by shuttle, separate where the mediator shuttles